And what happened, Sherry, was shortly thereafter, we started to see other states also taking similar action. Now, the other states, such as Florida, Ohio, Tennessee, these other states, they used different rationale and maybe slightly different reasoning, but it was all to the same effect. The effect being that, hey, maybe we don't need to be so restrictive. Maybe we have blocked bar admission to perfectly qualified people simply because of a bias about online education, or a requirement that somehow says we can't be trusted with the decision as to whether or not a school should be approved, so let's just let the ABA do it. I don't know about you, but I'm a Texan. I didn't like that at all.
Welcome to today's Heart of the Hustle. I am back with my friend Nelson Locke. Welcome back.
Thank you.
So glad you're here. Okay, so if you're here, we've got some updates on what's going on. First, give us a little background on, if you haven't seen your other episodes, give us a little background on what you've been working on, what's the legal case that you've been working on, why it's important, and then we'll go into what's happening now.
Sure. I think there's been a fair amount of press about this, most of which has been the result of your hard work, and I thank you for that. I think that if the people that are watching this spot would like to go to Heart of the Hustle's website, or go to locklaw.us's website, you'll be able to find some of the pre-recorded sessions we've done, which explain what it is that I pursued and what we've accomplished and where we are today. In a nutshell, the bottom line of this was that I'm a licensed attorney. I had about 11 years of practice as of this year under my belt with a license from another state. I had applied for a license in Texas, and I was told after 2 years of elongated, exaggerated investigations that my education was basically no good, and that the only cure I had was to go back to law school and do it all over again.
And why did they say that?
They said that because my school, which is Purdue Global Law School, not a name to be taken lightly, as a matter of fact, the first online law school in the United States ever. I think it's 25, 26 years old now. Purdue Global was not an ABA-approved law school.
And the ABA being the American Bar Association.
Yes, the American Bar Association. Okay. And the reason it wasn't an ABA law school was because the ABA saw fit to say that a completely, totally online legal education would not meet their criteria. Yeah, go figure. Because the bottom line of all of this, and for those of you that are listening, if you're in the legal profession, you know what I'm about to say. The bottom line of all of this is whether or not you pass a bar exam. It shouldn't matter if you went to law school on the moon. If you passed the Texas bar, you passed the California bar, you passed the Florida bar, you're a lawyer. That's the end of the conversation. And I am here to tell you that in all of my years now of operating my law firm and providing the compliance services that I do to all my clients all over the U.S., no one, not once, has ever asked me where I went to school.
Right.
All they want to know is, do I have a bar license?
Yep.
And that's what's important. So anyway, we're here because the story continues to roll.
Yeah, because you then went, you took it to court. Mm-hmm. It got all the way to the Texas Supreme Court.
Yes.
And they... tell me this might not be the right legalese, but they ruled in your favor.
No, I think that's a good way to say it.
Okay.
That's what I think everybody would understand. They didn't take it to the Supreme Court. Basically, I did, because the reality of it was I just kept butting up against closed doors and closed minds and bias and all kinds of problems with the Texas Board of Law Examiners. That's quite a protective society. And it just wasn't open-minded at all to the argument I was making. Yeah. And they spent a lot of time telling me why I was basically unqualified when, in fact, they should have been looking at how qualified I was. So that was a big, big problem. So when I finally reached the second rejection and they came back with that absolutely ridiculous cure, which was, well, Mr. Locke, why don't you just go back to law school and get another law degree and then we'll let you in? I think I pointed out at the time they said that to me, I was 73 years old. Now, come on. I'd like to live forever, but I'm not so sure that's going to happen. So the bottom line of it is to go back to law school for another 3 years and then take another year to pass yet another bar exam. I would have been 79 or 80 years old.
Yeah.
I don't
And
think...
you had already passed a bar.
Exactly.
There's no reason for you to go back to law school.
Right. So what we did is we put together a legal mechanism, which was really a two-pronged request of the Supreme Court. One of the Texas Board of Law Examiners' positions was that they had no supervision, that they were the final word, and that I had no right of appeal for any decision they made unless it was related to my moral character. Well, my moral character's fine. I don't have any skeletons in my closet. I don't even have any closets. The bottom line of it is that was, that's kind of like something that did no good for me. What my argument with the Texas Board of Law Examiners was the flawed reasoning and the unfair basis on which they were keeping me out of the Texas bar. So we crafted, working with my legal team, we crafted a two-pronged approach which consisted of a petition for administrative review, which in due process is always someone's right in America, okay? Whether the bar examiners think it isn't or not, it was. And I was right. But in addition to that, I added,
or in the alternative, writ of mandamus. Now, writ of mandamus, fancy legal words.
What that basically means is it means that the Texas Supreme Court, I was asking them to just tell the Texas Board of Law Examiners to admit me. Now, I didn't think that one would necessarily work, but I knew that they would take a hold of the review because I knew that these people that serve on the Supreme Court, the 9 justices, were level-headed and proven and thoughtful and well-versed with the issue that I had brought forward, and I knew that I would get a fair decision out of them, so I was perfectly fine with an administrative review. Had they decided against me, I would have walked away and done something else with Texas, okay? But I wouldn't have continued to push it. But what happened was, after just a little more than a year of review by the Texas Supreme Court, the Texas Supreme Court ruled, you said in my favor. It can only be construed that way because what they basically did was, the first thing they did was they released an order saying that they had looked at my file, they looked at my qualifications, they looked at my background, they looked at my education, and they said that, Mr. Locke's qualified. They said that.
Yeah.
And then they basically said, we hereby order the Texas Board of Law Examiners to go back in and look at his application a second time. Now, you know what that meant.
Right.
Okay, so what happened?
Let the guy in. That's what that means.
Yeah,
Let the guy in. Give him his card.
Basically, give him his bar card. So what basically happened was, within a day of that ruling, the Texas Board of Law Examiners was moving fairly quickly, and within a week or 10 days of that ruling, I actually had my Texas bar card, and I think you attended my swearing in Judge John Roach's court in McKinney, Texas.
Yeah, and we have a video of it on both my channel and on yours on YouTube.
And that was a very proud moment. So there we are. That was the first ruling. Then, shortly thereafter, there was a second ruling from the Texas Board of Law Examiners that said,
and they didn't say, thanks, Nelson.
I don't know. It would have been nice if they'd said thanks, Nelson, but I didn't really expect that. The bottom line is I was just glad they recognized all the issues. What they did was they basically said in their second order that they wanted to look at the whole matter of the ABA being the final word about law school admission in the state of Texas. And they posed the question, why can't we make this decision ourselves? We represent Texans. We're the Texas Supreme Court. Why don't we control this instead of an outside agency telling us what to do?
Because the American Bar Association, is it a government agency or it's a private agency?
No, it's actually a private enterprise. It's what's called an accreditation, programmatic accreditation agency.
Okay.
And what that basically means is it really doesn't have, I guess you could make a stretch and say, is it quasi-governmental? It might be because it's so broadly used, but it really is like a corporation,
right? Like
so many others. And the ABA does some good things for the legal profession. Don't get me wrong. The code of conduct is outstanding. The ethics supervision is outstanding. They do educational things which are outstanding, but they also do some things that are just not so outstanding, such as, especially after COVID, such as saying it's impossible for somebody to get a decent education online, so therefore you got to go sit in a classroom and listen to your professor. The Socratic method. You know how that goes.
Yeah.
Well, I'm here to tell you that isn't the case. And Purdue Global, in my filings in the court, we had some amicus brief participation from the dean of Purdue Global, Martin Pritikin. And in that, he recited some of the bar passage rates and some of the success stories of Purdue graduates. And it's impressive. It's very impressive. And there are many, many bar administrations recently
where the Purdue graduation, the Purdue successful pass rates
were higher than those of ABA schools. So, I mean, what's the point?
So Texas says, hey, why are we relying on this third party to make decisions on who gets to be attorneys in our state, right?
Yes.
So that's that happened after you were admitted, and then what? So what
well,
happened?
they opened a period for comments. By they, I mean the Supreme Court, and this is common. This is also part of due process. You see it in action, and they got comments. They got comments from I believe it was 10 law schools in the state of Texas, 8 of which. This should be no surprise to anybody. 8 of which said, "Oh no, we need the ABA. Oh, we can't think, we can't function. We'll just be paralyzed if we don't have the ABA." But one of them, UT, I believe, their president wrote a paper in response where he said, "You know something? This might not be a bad idea because there are things about Texas that Texans should control. Furthermore," and then he said it. He basically said, "You know, if they can pass the bar, what's the point?" He didn't say it in those words, but you know what I'm saying. And he got the picture. So we had 9 schools that argued against relaxing the ABA control over bar admission and over law school approval in Texas, and we had UT standing there alone with Purdue Global. There were some other smaller schools, but that's really the picture. And you know what? The Supreme Court took all the comments, said thank you very much, and then a few months after that came out with a ruling and said, well, we've decided we can do this without the ABA. So 9 Supreme Court justices, just like there were 9 in my case, there were 9 in that ruling.
And basically the 9 said, we'd like to reassert our authority over the
bar admission process in the state of Texas. And then they said, we're going to be putting out some amendments that we're going to suggest, and we're going to task the Texas Board of Law Examiners to make these changes, and Texas is moving on. Well, that was wonderful. And what happened, Sherry, was shortly thereafter, we started to see other states also taking similar action. Now, the other states, such as Florida, Ohio, Tennessee, these other states, they used different rationale and maybe slightly different reasoning, but it was all to the same effect. The effect being that, hey, maybe we don't need to be so restrictive. Maybe we have blocked bar admission to perfectly qualified people simply because of a bias about online education or a requirement that somehow says, we can't be trusted with the decision as to whether or not a school should be approved, so let's just let the ABA do it. I don't know about you, but I'm a Texan. I didn't like that at all.
Yeah. So here in Texas, then, the ABA is kind of out.
Well, I wouldn't say out. No, I wouldn't say that. I would tell you that on January 6th, there was yet another ruling, and that's one of the reasons why we're here. And this one was captioned, this is Supreme Court of Texas 26-9002, and this one is headed, it says, Final Approval of Amendments to Rule 1 of the Rules Governing Admission to the Bar of Texas. Now, it's not really final approval of amendments. It's really more along the lines of instructions to the Texas Board of Law Examiners and to other parties that are involved in the process as to what the Supreme Court would like them to do. And I'm going to just drop down, if it's okay with you. I'd just like to cover what I think is important. I think it's important that I go over this because I notice a pattern with many people who are looking at our social media and looking at LinkedIn and looking at
Facebook and looking at what Hire the Hustle publishes. And you know what, guys, it's not
personal, but you don't read. You don't read the background. You don't look at the material that's attached. And you know you really need to, before you have an opinion, soak up what the argument was. Okay? I think that's pretty important. So therefore I
We're
thought,
in a very fast culture these days.
yeah, we are.
We got what they're saying, we have a less attention span than a goldfish.
Yeah, well, my attention span, I've trained myself, and this is probably that Purdue Global online law school education plus the Marine Corps. I've learned to always make sure I've done my homework before I utter my opinion. Okay, my opinion can be completely wrong, but at least it's coming from a position where I considered all the facts. Okay, so that's why this is here. And item 5 in this one rule, it talks about this time. It talks about law schools that what the Supreme Court wants to do is provide stability, certainty, and flexibility to currently approved law schools. Okay, so, there were some law schools that are on the approved list, all of them, as a matter of fact, that are ABA approved, and they were thinking, well, what does this do to us? Well, it does nothing to them. Okay? It doesn't cause them to drop off. It doesn't cause them to have to reapply. They just continue status quo as long as they continue to meet a few requirements. Now, those requirements are still tied to the ABA, but I'll tell you what those are in a moment. Okay? So all the Supreme Court said was the present list of approved schools, those schools need only ensure compliance with certain ABA standards in order to maintain ongoing approval by the court. Sounds like a contradiction to getting the ABA out of the process, but it's not really, because here's what they want compliance with. The first one they want compliance with is Rule 316, and that's the rule about pass rates. Okay, now this makes perfect sense to me. It's completely logical.
A law school that's on the Texas approved list, the Supreme Court has said, has to meet the ABA standard
316, which says that you have to have a pass rate of 75% or so somewhere within the 2-year period prior to the review that's being done.
That makes
okay,
sense.
so that's reasonable.
Sense.
That's reasonable. That sounds like okay, yeah, we want to see, once again, we want to see that people can pass the bar and properly provide legal services to consumers here in Texas. The second rule, which is 502, is one that is really talking about ethics and communication. And I like that, okay? And listen, that part of that is kind of what you and I do when I tell you to be sure you get certain disclosures on the bottom of everything. Those are some of those rules, okay, about ethics and communication. Don't overstate. Don't misrepresent. Try to do your best job to be clear, and so on and so forth. Always make sure that the consumer is getting the truth to the best of your ability to tell it. That's what they're saying. I have no argument with that. I think that's also good. Then Rule 503. And Rule 503 had to do with applications to law schools and the fact that traditional law schools have required the LSAT. The LSAT is a logic test. I took it back in 1977. Right. And I passed it. Okay, it was okay. I passed it, and I went for a short time to an ABA-approved law school. But then I got transferred in my job and had to drop out. So I took it up in 2005 because I was running a business. I needed an online law school. Well, what Rule 503 talks about is it says that to be an approved law school in the state of Texas, you have to have at least some kind of an admission test that demonstrates the same intent and the same kind of careful gatekeeping that the LSAT represents.
Is there an alternative to the LSAT or the
Sure, Purdue Global has its own
admission test, for example. So this is speaking directly to something that Purdue Global as let's use them as the lodestar. Have you ever heard that term before? Okay, term of law. See? Lodestar means the measuring device, the indicator, okay, to the best of my ability to express it. So maybe what they're doing here is maybe they're making Purdue Global the lodestar when it comes to application exams, because Purdue has an application exam. It's not like what you do when you go through the LSAT, but it gets to the same place. Okay? All right. I would point out that no law school in their right mind is going to have a application exam that is so simple that anybody gets in, because what would that do to the pass rates? It would cause the pass rates to fall, and when the pass rates fell, you wouldn't meet ABA standard 316. So see how that goes around the circle? So I think that that's Okay with me again. And then 509 is the last one that they cite, and that talks about consumer disclosure. And once again, that's just a transparency issue. I have no problems with that. So the ABA standards are 316, 502, 503, and 509. No big deal here. I completely agree with what the Supreme Court did. Not that my approval is required, but I did want to say that I see these as logical. Okay. The second point the Texas Supreme Court made was they want to be sure that whatever changes they do ensures and preserves the portability of Texas law school degrees into other states. But then the Supreme Court goes on to repeat the second half of the sentence that they had in the original order, which says, and to preserve the portability of out-of-state law school degrees into Texas.
Which is a direct result of what you did.
I think so. I mean, but listen, Purdue Global Law School is a fully accredited by a state
accreditation agency law school. Okay? It just wasn't ABA.
But as far as California, a fairly large state, as far as California was concerned, my Purdue Global degree was the same as any ABA school within the four walls of the state of California. So why wouldn't that work in Texas? Well, what the Supreme Court is saying here is let's ensure the portability both in and out, which I think is good. Then they make a point that they don't intend to impose additional accreditation, compliance, or administrative burdens on currently approved law schools. Good statement. They're just saying we're not going to make it harder for you. We're not maybe going to make it a little bit easier for you, but we're not going to make it harder, okay? And then they say, and we will not take additional action in order for a school to remain an approved law school in Texas. So in other words, just fit these criteria, help us preserve the portability, and you're going to be good. That's what they're saying. Yeah. Criteria, of course, including bar passage rate. And then they've got a point on here that I just kind of skip over, that if a school loses ABA accreditation, does that mean that the school is going to have to be removed from the Texas approved list? Well, no, because it's no longer a requirement that they be ABA approved. The final one I highlighted here, and this is really the issue, is the Supreme Court said that they intend to develop, in consultation with the Texas Board of Law Examiners, a deliberative approach to requests from law schools not currently accredited by the ABA. Okay, well, you're talking about schools like Purdue Global Law School. And what does this mean? This means that the Supreme Court has tasked the Texas Board of Law Examiners with a responsibility now to develop what it is that they want to look at, the Texas Board of Law Examiners, and then the Supreme Court is going to approve it. I have a little bit of an issue with this one, but it has nothing to do with the Supreme Court. It has to do with
the TBLE. That's the short acronym for Texas Board of Law Examiners. Why do I say that? Because it took
them 3.5 years of dancing around with Nelson Locke for me to get a bar card. And my issue was pretty simple. I had work product. I had an existing license from another state. I had a perfect record. I had no moral character issues. Everything was good. Matter of fact, I'd never been so good. Okay, I was Snow White, and it took them 3.5 years.
So did the Supreme Court put a time frame on that?
No.
Okay.
And see, that concerns me a little bit, and I'm hoping that the good people at the Supreme Court are aware of the fact and took note of the fact that the TBLE danced around with me for 3.5 years, and the reality of it is they could very well do the same thing with writing their rules. If history means anything, they could do the same thing with writing their rules for admission for non-ABA law schools. I know that the dean of Purdue Global, Marty, if you're out there, I'm going to speak for you for a minute. I know that Martin Pritikin is working right now on trying to determine what the heck it is he has to do to get Purdue Global approved. And if you remember, when I did get my bar card, I had made an issue with Texas that they didn't even have Purdue Global on their list of law schools, period, approved or otherwise. That has been corrected. But Purdue is not on the approved list. It's just on the list, okay? So you can now proudly, if you are granted admission in Texas, you can proudly say you went to Purdue Global Law School, probably, well, certainly the gold standard for online education. So the purpose of this podcast was for me to kind of bring you up to speed, and I think I just did so, Folks, I don't think that this is over. I think that this is under control, and I think it's moving in the right direction. And I think we need to be patient, and we need to
Respond or ask for any feedback or comments by the Supreme Court so that they
have the guidance from those of us that are out there in the trenches and understand how we feel about how the Texas Board of Law Examiners is following through on the mandate to develop a deliberative approach. You know, that's a key word too. What does that mean, a deliberative approach? That means a fair approach to me. It means a thoughtful approach. It means an approach free of bias against online. That's what it means, okay? So that's all I have for this particular podcast.
Yeah, that's great. But we're going to do a part 2.
Yes, we are.
So stay tuned. We're going to do a part 2 because this is spreading like wildfire to other states. And so we want to talk about that, but we're going to do a part 2. So stay tuned for that. And so happy to have you here. And we'll see you in part 2 in a few weeks.
Okay, and I'll just close with this. Part 2 is I'm going to address some of the recent decisions Florida has made, because I can tell you from the communications I'm getting via social media and email, there are many online graduates who have been concerned about Florida's prohibitions as well. So we'll talk about that.
Great.
Thanks, Sherry.